All right, Mr. Ram, do we have anyone ready in the jail?
Yes, Your Honor.
All right, Mr. Manning,
See you, Judge.
who are you ready on?
We can start with Mr. Ehrenfeld.
All right, court calls number CR 23-106, State versus Kevin Max Ehrenfield. I show it's set for motion to revoke, possibility of a plea today.
Yes, Judge, we reached an agreement. Unfortunately, it was due to some issues with the credit time. We were unable to get the paperwork for today's hearing. We request that he be set on Thursday to go ahead and go forward with that plea. It'll be for 12 months state jail. And I believe we're going to request, I haven't talked to the state about this at this point, but we're going to request if we can do that under 1244A because I believe he does have time credit based off of the time he's been in this county and others.
All right, so for purposes of what the court needs, you want me to reset this to Thursday for the second, and let you and the state work out the details?
Yes, Judge.
Any objection from the state?
No.
All right, court sets Mr. Ehrenfield to enter his plea before the court on Thursday, May 2nd at 1:30.
Thank you, Judge.
Who are you ready on next?
Judge, next, ready on Mr. Watkins.
Court calls CR 20-201, State versus Michael Watkins. Go ahead, Mr. Manning.
Judge, this was one we were ready to go forward on for a hearing. We talked to the state. They offered a new offer. My client, it was within the range of agreement that my client and I had discussed. However, today he has discussed some new information that he's brought to my attention that he would like for me to investigate before we go forward. Out of abundance of caution, I feel like that's an appropriate thing to do as it may be vital to his case. I would ask for just a short reset and ask the state to hold that offer while I do this investigation that he brought to my attention this morning.
How many settings have we had on Mr. Watkins on the motion to revoke? Is this the first or second?
Judge, I believe I've appeared at least once with Mr. Watkins, but I don't believe that I've appeared anymore with him.
State have a position?
No objection to a reset as for holding the offer open. It would really depend on what we're tracking down. Of course, I'll consider keeping it open. I don't know what we're talking about though, so I can't guarantee that the offer would remain open.
Judge, it may be a possible 1107 issue. And as I said, Judge, I just found out about it today. My client feels uncomfortable until I have reviewed the information that he's found. He's uncomfortable going forward. And so I'd ask just to be given a short week or so to be able to review that.
Yeah, well, jury hearing, which the court could take this up, is going to be May 30th. So
Judge, sorry, we lost you. You glitched there.
I said, unfortunately, I can't accommodate a reset because this case would have to be set on the next evidentiary docket for us to take testimony. So that's necessarily going to be 30 days.
Okay.
So it's not, if it was just something as easy as reset for a week and then have the hearing, it'd be different. But fortunately, that's not the position we're in. We're in a 30-day holding pattern if agreement. Let me review his case real quick to see how many settings we've had on this, and then I'll let you know about his request.
Thank you, Judge.
Mr. Manning, it looks like we were set previously on April 18th. I think you were appointed 1st of April. We appeared on the 18th and then we reset. So this appears to be the first evidentiary hearing that we're having.
Yes, Judge.
Watkins. So he understands that the state's indicated that they're not necessarily going to hold that offer over. So that being the case, does he still wish to go forward with requesting for a reset?
Judge, I have spoken to him about that possibility. If I may have just a moment to consult with him and see if that's still what he wants to do.
Yes, sir.
Judge, he's fine with resetting that.
All right, court's going to set Mr. Watkins for a final hearing on his motion to revoke on Thursday, May 30th. 1:30. What else you ready on?
Next ready on Mr. Dalen Blue.
Dalen Lee Blue, CR 23169, motion to revoke. Go ahead, Mr. Manning.
Judge, Mr. Blue's been housed out of county, and so I received an offer and was able to discuss it with various members of his family, but not able to discuss it with Mr. Blue till today. That offer involves the state withdrawing their motion and amending to include SafeP. My client agrees to that, and if the court will permit, I believe we can probably get him signed and get him on the list for a bed starting today. If that's all right with the state and with the court.
So the state's extended an offer and your client's accepting it?
That's correct, Judge.
Okay, but we don't have paperwork today?
I believe we can have the motion amending signed today. I just don't know when the state would be able to produce their paperwork.
Your Honor, we can get our paperwork together pretty quick. I wasn't able to confirm with probation that they were in support of the offer. But if they are, then we can get that motion drafted fairly quickly.
Did you hear that, Mr. Manning?
Yes, Judge. I can have Ms. Burns speak to their position on that.
Mr. Manning and I spoke and we're in agreement.
Okay, probation is supportive, okay. All right, then, yes, we'll recall Mr. Blue's case, and give the state some time to produce the paperwork.
Thank you, Judge. Last one I have, Judge, is Mr. Tyler Donica.
Tyler Scott Donica, CR 21285.
Judge, I had an opportunity to speak with Mr. Donica for the first time last week and go over some of the stuff with this case. We request a reset to the May 30th docket for a contested hearing.
Any objection from the state?
No objection, Your Honor.
All right, court finds that Mr. Manning was appointed in April 2nd, this being the first contested setting. The court will grant that request and reset Mr. Donica for a final hearing on May 30th at 1:30.
Bravo 1.
Mr. Manning, what about Anthony Maris?
Judge, we have an agreement on Mr. Maris, but there was an issue with some of the paperwork in regarding his time credit. I sent the appropriate, what the defense believes is the appropriate time when the hold was placed on Mr. Mars. I sent that to the state, and they're reviewing that. I also have something to speak to Mr. Hartwell about in regards to the judgment. One correction I might have caught, but other than that, I think we will get that taken care of today.
Okay, very well.
Judge, I believe that is all I have it ready this time.
Thank you, Mr. Brandon. Mr. Bingham, are you ready on Mr. Bahina?
We are, Judge. Thank you.
All right, court calls number CR 18-456, State versus Julian Martin Bahina. And is it my understanding that there is a plea in this case today?
That's correct, Judge. He's pleading true to all the allegations, I believe, in the state's amended motion to adjudicate. He's on deferred adjudication probation. He acknowledges he's the same person placed on probation. Pleads true to the allegations in exchange for a recommendation to the court of 6 months in the state jail facility, credit for the time he served, which is approximately 59 days, I believe, 57, 59 days. He's prepared to acknowledge that in front of the court.
All right, and you said that Mr. Bahina does waive the formal reading of the motion to adjudicate?
He does. We've been through it many times. He's familiar with what's in it.
All right, Mr. Bahina, sir, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. All right, Mr. Bahina, the state has filed a motion to adjudicate and revoke your community supervision. They filed that on March 26th of 2024, and that was during your period of community supervision, in which on June 11th, 2019, you appeared before the court and you pled guilty to the state jail felony offense of theft of property between $2,500 and $30,000. And in this motion to adjudicate, well, let me back up. So the court on that date, June 11, 2019, heard your plea of guilt, took it into consideration with the recommendation from the state, and the court did not adjudicate your guilt on that date. However, the court deferred a finding of guilt, placed you on community supervision for a period of 4 years, ordered you to pay a $2,500 fine along with other fines and fees, court costs. Have you had enough time, in your opinion, to discuss this case with your attorney, Mr. Bingham?
Yes, sir.
And are you satisfied with Mr. Bingham and the work he's done for you?
Yes, sir.
Is there anything about your plea agreement today that Mr. Bingham read onto the record that you do not understand?
No, sir.
Okay. And Mr. Bingham, you do believe Mr. Bahina to be competent?
He is competent.
All right, Mr. Bahina, then I'm going to ask you at this time, how do you plead to counts 1 through counts 1 through 16 as contained in that motion? Are those counts true or not true?
True.
And are you telling me that each one of those counts that are alleged is true because in fact what is alleged is in fact true? You're not just telling me it's true to reach a certain plea agreement.
No, it's true.
It's true. All right. Thank you, Ms. Bahina. Ms. Bahina, has anybody threatened, forced, or pressured you to plead true to any of these counts?
No, sir.
All right. The court will accept the defendant's plea of true to each count. Mr. Bingham, any objection to the admission of the defendant's waiver of rights of plea of true into evidence?
No, we would join and ask that it be admitted.
All right, that is admitted, and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor.
Anything further from the defense?
We do have one thing, Judge. We, as the court knows, state jails serve day for day. There was a House bill passage back in 2015, 2649, that allows for the court to preemptively give any credit earned by the defendant for diligent participation in programs at the state jail. Normally, they'll send that 30 days prior to release back to the court for the court to consider. This is a motion we filed in numerous counties, just asking the court if he does do that, satisfies the state jail, I'll go ahead and preemptively give him credit if the state jail is satisfied he's done it. I thought I was gonna be in person, last time, and I did not, e-file it. I can give it to, Patty and, or, I'm sorry, I shouldn't call you by your first name, but, if for the court to consider, just preemptively giving that credit if he participates in the diligent, I guess they call it diligent participation in designated state jail programs. And that way, if he does satisfy that, he would get 20% off his sentence.
Yeah, the court doesn't preemptively give that. What the court does do, though, is the Texas Department of Criminal Justice will notify me of all offenders that are eligible for that diligent participation. And in doing so, they will let me know if he's enrolled in any kind of educational courses, vocational courses, and they'll also alert me to any disciplinary history. So the court's policy is what I do is I review the educational participation, the vocational, and also take into consideration any disciplinary problems. And once I check that every month. And so once the state TDC notifies me, then I will review that online. And it is the policy of the court to grant that to those individuals. And the TDC will tell me how many days I can give, the maximum, anywhere from 0 days up to the maximum, whatever 20% of their sentence is. And the court does review that and make those discretionary judgments at that time once I receive the records. So I can tell Mr. Bahina that I will be reviewing that, and anything that's good on there will be to your benefit. Anything that's bad on there will be to your detriment when I determine whether or not to give you those credits.
All right, thank you, sir.
Okay. All right. So based on the evidence presented to the court today, court finds that there is sufficient evidence to convict Mr. Julian Martin Bahina of theft of property between $2,500 but less than $30,000, a state jail felony. The court adjudicates his guilt based on the plea agreement, does follow the plea agreement, adjudicates his guilt, revokes his community supervision, assesses his punishment at 6 months confinement in the state jail division of TDC, orders him to pay the balance of his financial obligations, including the reimbursement fees, and the court will award Mr. Bahina 59 days credit towards his sentence for the time that he's already spent in jail on this cause. Mr. Bahina, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of this sentence. I'm gonna have you step over to be fingerprinted.
Judge, that's all I have. I appreciate the court getting us in today and have it excused.
Yes, thank you, Mr. Bingham. Good to see you.
Yes, sir.
Mr. Schmidt, who are you ready on?
David Pesnell. David.
All right, this is cause number CR 21-183, State versus David John Pesnell. Motion to revoke. Go ahead, Mr. Schmidt.
Judge, we're not quite ready to proceed, but we're gonna ask for an additional setting on his motion to adjudicate.
Is there an issue as to readiness?
Well, an issue is that we're negotiating with the state. I met with Mr. Hartwell on Friday. I was able to relay the current offer to Mr. Pesnell today. I need to discuss it further. And I'd like to meet with Mr. Hartwell again prior to an actual contested motion. I believe we'll be able to resolve it.
Any position about the state?
Your Honor, state's unopposed to a final reset.
All right, court finds that Mr. Schmidt was appointed March 26th for the first time, and I believe that a first hearing on the motion to revoke was we had a status hearing, I believe, on April 16th. This being the first contested evidentiary hearing. The court will set Mr. Pesnell for a final hearing on May 30th at 1:30.
You're on.
Roll.
Go ahead and step over there.
Mr. Harden, are you ready on Miss Lewis?
Yes, Your Honor, we are.
All right, this is cause number CR 22-357, State versus Jodine Walters Lewis. Motion to revoke. Go ahead, Mr. Harden.
Yes, Your Honor. After negotiation with the district attorney's office, the state has agreed to withdraw the motion to revoke and instead give my client opportunity to participate in drug rehab at safety and then come back with additional probation to be served. And as I have talked to the district attorney about the potential for giving Ms. Lewis the opportunity to be on a leg monitor for a couple of days so that she can get her house shut down. It's going to be a matter that if you discuss with the district attorney, they'll tell you that the circumstances that we've assisted the state on.
And Your Honor, state is unopposed. Really, we take no position on it. I wasn't sure what the court's position was, what probation's position was as far as getting an ankle monitor in place to allow her time to do that. I really take no position on it. I leave that to the court's discretion.
Under the third level of sanctions, Judge, it does list GPS as a potential. And that's the reason we'd ask for the court to consider that.
Mr. Harden, I'm reviewing our last few docket settings. If I'm viewing this correctly, I show that Miss Lewis did not appear in court on her last motion to revoke setting. I could be wrong on that, but let me look.
She was incarcerated, Judge, and has been for a long time.
Since last month, maybe like 30 days.
60.
She's been 60 days in Van Zandt.
Ms. Burns, do you have an opinion?
I do. We're in agreement for safety, but I'm not in agreement with letting her out. Right now, there's no wait for safety. So she could go.
If there's no way, then we're not opposed. But I still need to get her house shut down. She's a homeowner and
Mr. Harden, hang on. I'm asking for Ms. Burns' opinion, not yours yet.
I apologize.
Go ahead, Ms. Burns.
And if the court considers a GPS unit, we'll need to make sure that we have one on the site and the money will have to be paid up front, and we will have to place it on her before she's released.
And the cost is what, $300 for the first month?
Yes, sir.
And that full 300 has to be paid up front?
Yes, sir.
All right, Mr. Harden, I'm going to deny her request to be released on an ankle monitor. I have concerns about her sobriety while she would be released. So I think she's better off in custody and taking advantage of the rehab program with no wait than shutting down her house. So I understand that puts a hardship on her, but I don't think that that's going to be in the interest of justice.
We understand, Your Honor.
Okay, is this, do we have paperwork on Miss Lewis today, or do we need to get paperwork?
Paperwork's already been completed.
I need paperwork.
Yes, Your Honor, I'm sorry. I think I might have sent that over to the jail.
All right, do you have the paperwork over there with you, Mr. Harden?
Yes, Your Honor, we did. It's signed by the probation.
Okay, and so, I guess, Ms. Tabraham, can you put it in front of the camera so I can see what is written on there? Ms. Tabraham, can you take it and put it in front of the camera? Because I can't see back there. I like how y'all think I can see that far, but I can't. I just need to see what the state's motion is. got Safe P, no ISP, so just Safe P. Is it extended or continued? That's not marked. Is it,
I think we're continuing.
are we extending her probation or just
Continuing.
continuing? Okay, all right, thank you, Ms. Abraham. All right, Ms. Lewis, if you'll raise your right hand, I'm gonna place you under oath. Ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yeah.
All right, you can lower your hand. Ms. Lewis, I understand what your agreement is with the state. I need to know, has anybody threatened or forced or made you feel like you had to enter into an agreement to go into rehab?
No,
Are you doing this because this is what you want to do in order to resolve the matter that you have before you?
yes, sir.
And you're represented by your attorney, Mr. Harden. Are you pleased with Mr. Harden and the work he's done for you?
Yes, sir.
Is there anything about this plea agreement that you do not understand?
No, sir.
Have you talked with the probation department to understand what the requirements are going to be once you come out of safety?
I haven't talked to them, no.
Do you understand it's going to require a halfway house and things of that nature?
Yes, sir.
You do? Is there anything that you're unsure about before we go forward?
No, sir.
Okay. All right, then the court will grant the state's motion to withdraw the motion to adjudicate warrant. Court will amend the conditions of community supervision to include placement at the substance abuse felony punishment facility. Ms. Lewis, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. So we're going to go ahead and get the order signed, and then Ms. Burns will have you placed on the safety list, and she says there's no wait, so hopefully you'll be picked up sooner rather than later, so you can start your path to recovery.
Thank you.
Anything further, Mr. Harden?
No, Your Honor, may I be excused?
Anything further from the state?
Nothing further, Your Honor.
Yes, sir, you may. Thank you, Mr. Harden.
Yes, Your Honor.
No.
Mr. Schmidt, who are you ready on now?
Brian Lunsford.
Brian Lee Lunsford, cause number CR 24-6. Is this a plea today, Mr. Schmidt?
It is, Judge.
Right. I don't believe I have the. Let me check.
I've got two sets over here, so you probably don't.
No, there it is. I do have it. All right, let's see. It looks like Mr. Lunsford would be pleading guilty today to a charge of burglary of a habitation, a second-degree felony. The recommendation from the state is upon conviction, 4 years confinement in the Texas Department of Criminal Justice, a $500 fine. The state would be including an evading arrest or detention under 1245. $500 fine, $290 court cost, $20 reimbursement fees, and 173 days credit towards the sentence for time that he's already been in jail. Does that sound right to you, Mr. Schmidt?
Yes, sir.
Mr. Lunsford, does that sound correct to you as well?
Yes, sir.
All right, Mr. Lunsford, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth? So help you God.
Yes, sir.
All right, thank you. You can lower your hand. All right, Mr. Lunsford, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt's representation?
Yes, sir.
Do you feel like you've had enough time to talk with him about your case to the point that you understand your legal rights and everything that you've read and signed today?
Yes, sir.
Mr. Schmidt, do you believe Mr. Lunsford to be competent? And if so, have you explained to him his rights as they pertain to this case?
I have, yes.
And do you believe that he is entering into this plea intentionally, knowingly, and voluntarily?
Yes, sir.
All right, Mr. Lunsford, the range of punishment for a second-degree felony offense of burglary of habitation is not less than 2 years in prison or more than 20 years in prison, and a fine not to exceed $10,000. I find today that the recommended plea agreement does fit lawfully within the allowable range of punishment. Understanding the plea agreement and the range of punishment, Mr. Lunsford, I would ask you at this time, how do you plead to burglary of habitation?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes.
Has anyone threatened, forced, or pressured you to plead guilty?
No.
Court accepts the defendant's plea of guilt. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
All right, stipulation is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the statement?
Nothing so.
Anything further from the defense?
No, sir.
All right, court's going to review the stipulation. Mr. Schmidt, do you have the stipulation with you?
You have a stipulation, yes.
Can you recite that stipulation for the court?
Yes, sir. On or about November 9th, 2023 in Van Zandt County. Brian Lunsford went into the home of Gladys Cesares without permission and gathered multiple items, including pillows, blankets, and towels, intending to steal them. When leaving, he saw the law enforcement was approaching and left the items at the home prior to being arrested.
All right, thank you, Mr. Schmidt. All right, the court has also been provided with a victim impact statement. Court has reviewed that prior to determining the sentence in this case. Mr. Hartwell, in this victim impact statement, there's a reference to over $18,000 worth of restitution. Is there any issue that should come before the court on that matter?
If Your Honor would give me just a moment to get into the case and see if we were provided any supporting documentation on that.
Yes, sir.
Your Honor, as for this incident, the only record I have is the value of the property that was found was approximately $100. However, I have been made aware that there have been multiple burglaries at this home, but I don't have any evidence connecting anything to that amount to this particular case.
All right, so the state's not recommending to the court that any restitution be recovered from this defendant.
Correct, Your Honor.
Okay. All right, then based on the evidence presented to the court finds that there is sufficient evidence to convict Brian Lee Lunsford of burglary of habitation. The court does follow the plea agreement today, convicts him of that offense. The Court assesses punishment pursuant to the plea agreement at 4 years confinement in the Texas Department of Criminal Justice Institutional Division. Orders him to pay a $500 fine, $290 in court costs, $20 in reimbursement fees. And the court dismisses under section 1245 unfiled DA 2023-959, evading arrest or detention. Court awards Mr. Lunsford 173 days credit towards the sentence for the time that he's already spent in jail on this cause. Mr. Lunsford, you hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you're released from the prison, then you need to report to Van Zandt County Courthouse District Clerk to discuss paying off your fines, court costs, and reimbursement fees if you don't have them paid off by the time you're out of prison. Do you understand?
Yes, sir.
All right, thank you. Step over to Big Fingerprint. Mr. Schmidt, who are you ready on next?
Christopher Gage.
Christopher Matthew Gage, cause number CR 13247. Go ahead, Mr. Schmidt.
Judge, we're asking for an additional setting on the contested motion to revoke Mr. Gage's probation. Have more opportunity to speak to the state on this issue.
Court's going to set a final hearing for May 30th at 1:30. Who's next, Mr. Schmidt?
Charles Howard.
This a writ?
It is, Judge.
All right, this is WR 24-21. Charles Justin Howard versus State of Texas. Go ahead, Mr. Schmidt.
Judge, I'd call Charles Howard for the purposes of the writ requesting a bond reduction.
Mr. Howard, raise your right hand. I'll place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand, speak up loudly and clearly. Go ahead, Mr. Schmidt.
You are Charles Justin Howard, correct?
Yes, sir.
And you were arrested on these charges February 12th, 2024, is that correct?
Yes, sir.
As of today's date, you've been in custody approximately 79 days,
Yes, sir.
and your bonds are set at $130,000, is that correct?
Yes, sir.
And at this point in time, have you made any efforts to see about making a $130,000 bond?
Yes, sir.
And are you able to do that?
No, sir.
Do you have the resources, property, money and accounts in order to come up with the amount to post a $130,000 bond?
Not even closer.
Now, you have filed an affidavit of indigency with this court, listing all assets, et cetera, and you were found indigent by the court, is that correct?
Yes, sir.
And those, all of the disclosures that you put on that affidavit of indigency, have they changed or are they still the same?
They're all the same. So,
At this point in time, do you think that there's an amount that you could come up with to post a bond?
Well, I have, my fiance, she has a job. I have a job when I get out.
But do you think that you could post an amount? And if so, what?
If you could drop that 100,000 off there, I probably would make that.
So are you telling the court that you think you could post a $30,000 bond?
Yes, sir.
Now, if the judge was to approve your request and you were able to bond out, you understand you'd be under conditions of pretrial release.
Yes, sir.
And you're aware generally what those conditions would require of you, right?
It's, reporting, paying my fees, passing drug tests, showing up in court. All the above. Yes, sir. I just walked 3 years of pre-trial. Yes, sir.
And so you're telling the court that you'd be able to abide by those conditions.
Most definitely.
And in addition to that, where would you reside if the judge were to grant your release?
At my mother's house.
Where is that located?
It's in 3738 Van Zandt County Road, 4907 in Ben Wheeler, Texas.
And would you have transportation to and from court?
Yes, sir.
And previously you were on pretrial. Those charges were dismissed against you, correct?
Yes, sir.
But you did report to this court on pretrial release as well as all court dates.
Passed every year analysis test with the judge, with the pretrial, I paid. Yes, sir.
Now, you did have one incident where your bond was revoked for being late to show up for your reset. Is that correct?
Yes, sir. I showed up to the court and made the search.
And so at that point, you did show up, but you were late.
Yes, sir. And I bonded out and then I walked another year of pretrial. So,
You continue to comply with all the conditions.
yes, sir.
Do you have employment waiting for you if you get out?
Yes, sir.
And what would that employment be?
I do tree service. I work on the ground for a tree company. Out the side plan.
So you'd be able to pay your pretrial release fees, including supervision fees as well as court-appointed attorney's fees. Is that correct?
Yes, sir.
I'll pass the witness.
State. If you go ahead and turn off both microphones.
Good afternoon, Mr. Howard.
Are you logged in at all?
Pardon
Are you logged in at all?
I am not, Your Honor.
You log in so they can see you better.
You log in? I can get it quick.
Say something. They say something.
He said good afternoon, but so it's not to walk in.
Just make sure.
Thank you, Your Honor. Good afternoon, Mr. Howard. You've actually been convicted of state jail felonies, have you not, sir?
Yes, sir.
And when was your last parole date?
Parole date,
Yes, sir. When were you released on your last felony conviction?
2018.
Pardon me?
I believe 2018.
2018, okay. And you also have several convictions for theft of property, isn't that true?
I believe I have one for the state jail. I had the state jail. Yes, sir.
Okay. And so you're telling the court that you could make a $30,000 bond?
Yes, sir.
I have nothing further, Your Honor. Thank you.
Anything further, Mr. Schmidt?
No, sir.
All right, any further witnesses or evidence?
No, sir.
Do you rest, Mr. Schmidt?
Yes, Your Honor. Oh, pardon me.
Mr. Schmidt, do you rest?
We rest.
State, any rebuttal evidence?
No, Your Honor, state rests.
All right, argument, Mr. Schmidt?
No, Judge, we just asked based on what's been presented, we let the court grant relief. Mr. Howard, I'm sure the court's familiar with his compliance in the past, any issues he may have had. And we'd asked that you grant that so he can be working towards paying off his pretrial release fees while on pretrial.
And as Mr. Howard has been indicted on this case, correct?
Yes, Judge, the indictment was presented April 19th.
Okay, thank you.
Yeah,
Anything
and
further?
that's set for an arraignment on the 28th.
Okay, thank you. Anything further, Mr. Schmidt?
No, sir.
State, any argument?
No, Your Honor, rest on the record. Thank you.
All right, court will take the evidence under advisement. I'll issue a ruling at the close of the docket.
Thank you, Judge.
Thank you, Mr. Schmidt. Thank you, Mr. Howard.
Thank you.
Thank you.
All right, Mr. Schmidt, who are you ready on now?
Keith Stevens.
Going to call on Mr. Stevens for the purposes of the you gonna be calling Mr. Stevens for the purposes of the writ?
Oh, yes, sir. Sorry.
It's okay. Mr. Stevens, if you raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
Thanks, sir. You can lower your hand. Go ahead, Mr. Schmidt.
You are Keith Edward Stevens, correct? Yes, sir. And you were arrested and confined in Van Zandt County on March the 4th, 2024, is that correct?
Yes, sir.
You had previously been arrested on the same charges. I guess that was back in 2023, nearly a year ago, is that correct?
Yes, sir.
And you were able to postpone at that time. And your bondsman released surety on you or went off your bond, is that correct?
Yes, sir.
He went off your bond because of an inability to make your financial agreement with him?
Yes, sir.
And ultimately, that was the only reason he released?
Yes, sir.
So you were in contact with your bondsman, you just had a difficult time coming up with funds?
Yes, sir.
So as of today, you've been incarcerated or in jail on these charges approximately 68 days. Does that sound right to you?
Yes, sir.
And your bonds are set in a total amount of $60,000. Are you able to post $60,000 with the bonds? And you are currently unindicted on these charges, is that correct?
Yes, sir.
And is there an amount that you could post if the judge were granting you relief?
If possible, 20,000.
You think you could post a cumulative amount of 20,000? Or $20,000 on each charge? There are two charges. So $10,000 per charge?
Yes, sir.
With a total being $20,000.
Yes, sir.
And if the judge were to grant your relief, do you have a place to live?
Yes, sir.
And would your place, your residence be in a place that would be in compliance
Yes, sir.
with your pretrial release conditions? And do you have transportation?
Yes, sir.
And you can get back and forth to court if you were ultimately indicted
Yes, sir.
on these charges? That's my one question. Sorry. Okay. Where would you work if you were released?
I work for Paradise Foundation.
And what do you do for them?
I crawl underneath houses all day. I do foundation repair.
Foundation repair. And where do you normally live?
4257 FM 1255 Grand Slam, Texas.
And is that where you would go if you would make bond? And your transportation, if you were indicted, do you have a vehicle of your own or do you have your spouse?
I have my spouse and one of my own.
All right, I see. Now previously, in order to get a court-appointed attorney, you filled out an affidavit of indigency with the court listing all your assets and all your property. Is that correct?
Yes, sir.
Has anything changed on that affidavit?
No, sir.
And the court deemed you indigent at that time and
Yes.
appointed you an attorney? So you're asking the judge to reduce your bonds to a total of $20,000 past the limit.
State, any questions?
Just got vertigo really bad.
I know.
Hi, Mr. Stevens. You had previously made bond on these cases, is that correct?
Yes, sir.
And a surrender of principal was filed by Springer bail bond leading to your incarceration this time?
Yes, sir.
And are you aware of why they filed that surrender of principal?
As far as I know, for financial responsibility.
Not responding by phone or mail, not being in contact with your bondsman, is that correct?
They contacted my mother and I contacted them right back. Every time they contacted, I returned them.
So if they had an affidavit saying that you didn't, they would be lying?
Yes, sir.
And your bond amount on that was 30,000?
It was actually 60,000 to 30,000.
Oh, so two bonds, 30,000 each?
Yes, sir.
So what would be different this time to prevent those same issues from coming up?
The deduction bond is really the main deal. They let me out last time on barely giving them any money and I just couldn't continue paying it.
But as far as maintaining contact, making sure that we don't end up back here on another surrender of principal.
Whatever was required, if I can pre-trial relief or to supervision or anything like that, I'd be willing.
No further questions, Your Honor.
Anything further, Mr. Schmidt?
No, sir.
All right, court will take the testimony under advisement and will issue a ruling at the end of the document.
Thank you, Judge.
You're welcome. All right, Mr. Manning, who are you ready on?
Judge, ready on Mr. Maris? And Judge, your judgment may look a little different than ours, but I'll try to point out.
Yeah, go ahead and let me call this for the record, then you can tell me. Well, actually, before we get on the record, just tell me what your judgment looks like.
Judge, on the total time credit, it's gonna be 471 days. And then on the second page of the judgment, all of the violations under section A of the community supervision, those conditions, all those have been abandoned by the state. And so we're gonna be proceeding on D, G, M1, M2, M3, M5, and O.
So you said 471 days, 471,
That's correct, Judge.
and the original judgment said 147.
I'll take your word for it, but yes, Judge, it had significantly less days.
Okay. All right, Mr. Maris, we're gonna go on the record now, cause number CR 22-109, State of Texas versus Anthony Reimer Maris. Mr. Maris, if you'll raise your right hand. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, thank you. You can lower your hand. Speak up loudly and clearly for me. All right, Mr. Maris, you were appearing before the court back on May 12th of 2022, and you pled guilty to the second-degree felony offense of possession of a controlled substance, affiliate group 1, in an amount of 4 grams or more, less than 200 grams. The court heard the evidence that day, considered the plea agreement and the recommendation of the state, and the court followed the recommendation of the state in your plea agreement, and the court deferred a finding of guilt and did not convict you, but placed you on community supervision for a period of 7 years, and also ordered you to pay a $3,000 fine. It was during that period of community supervision that the state of Texas filed its motion to adjudicate your guilt and to revoke your community supervision. And in that motion, they filed 17 separate counts alleging various violations. And they filed that on April 24th of 2023. Have you had sufficient time to review that with your attorney, Mr. Jonathan Manning?
Yes, sir.
Mr. Manning, did your client waive the formal reading of the state's motion?
We do, Judge.
All right, and Mr. Maris, are you pleased with Mr. Manning's representation of you?
Yes, sir, I am.
You feel like you've had enough time to go over this motion with him, have all of your legal questions answered, and that you understand everything that you've read and signed today?
Yes, sir.
All right, then, Mr. Maris, I'm going to ask you then, how do you plead to counts 7, 8, 9, 11, 12, 13, 14, 15, and 16? Are those counts true or not true?
True.
And are you telling me that each one of those counts that you pled true to, you're pleading true to those because what's being alleged is in fact true? You're not just saying that to get a certain plea agreement?
No, sir, it's true.
All right. And Mr. Maris, has anybody threatened, forced, or pressured you to plead true to any of those counts?
No, sir.
All right, the court will accept the defendant's plea of true to those counts as alleged. Mr. Manning, any objection to the admission of the defendant's waiver of rights and plea of true?
No objection, Judge.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state,
Nothing further, Your Honor.
from the defense?
Judge, I would just say that my client had a significant amount of stuff that he had done while he was previously down in TDC in support of the mitigation in this case. He had done almost 200 hours of counseling, rehab. He had done work to get his GED as well as significant other projects that he'd taken on. in taking his steps toward rehabilitation. So Judge, I think this offer fairly reflects the tremendous amount of work my client has done to help equip himself for his sobriety when he does get out.
Thank you, Mr. Rainey. All right, then, based on the evidence before the court finds that Mr. Maris has violated the terms and conditions of his community supervision. The court will follow the plea agreement this date. Court hereby adjudicates the guilt of Mr. Maris, convicts him of possession of a controlled substance between 4 grams to 200 grams. Court revokes his community supervision, assesses his punishment at 8 years confinement in the Texas Department of Criminal Justice. The court orders him to pay a $3,000 fine, $180 restitution, $290 court costs, $70 reimbursement fees, and the court awards Mr. Maris total jail time credit of 471 days towards the sentence for the time that he spent in jail on this cause. Mr. Maris, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. Once you're released from TDC, if you've not paid off all your fines and fees, you'll need to report to the courthouse, to the district clerk's office, and inquire about a payment plan or paying those off, okay? All right, good luck to you. Step over to be fingerprinted. All right, who's next, Mr. Manning?
Judge, we're back on Mr. Blue. I received the state's motion and my client signed off on the modification to include SafeP as well as to amend his financial obligations. We signed off on that and he is ready to proceed.
All right, this is call number CR 23-169, State versus Dalen Lee Blue. Mr. Blue, raise your right hand so I can place you on oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can lower your hand. Mr. Blue, you are here today because the state of Texas filed a motion to revoke your community supervision based on the previous supervision order entered by this court. It's my understanding that you want to enter into a plea agreement with the state in which they are telling the court that they will withdraw that motion to adjudicate upon your agreement that you will enter into the substance abuse felony punishment facility, also known as SafeP, a drug rehabilitation program. In addition to that, that would be an amendment to your community supervision conditions that you must complete. In addition, you would have some amended financial obligations, including court costs related to attorney fees. Is that your agreement with the state? And has anybody threatened, forced, or pressured you to enter into that agreement?
Yes, sir.
Are you pleased with Mr. Manning and the legal work he's done for you?
Yes, sir.
Is there anything about this agreement that you do not understand or have questions about?
Yes, sir.
Okay, then the court will approve the state's motion to withdraw the motion to revoke. Court does follow the agreement. Court amends the community supervision conditions of Mr. Blue to include enrollment in the substance abuse felony punishment facility, and the court will amend his financial obligations to include additional court costs and the amendment of the attorney fees. All right, Mr. Blue, good luck to you.
Judge, I believe that concludes my business here. I'll be headed over that way to conduct Mr. Rodriguez's hearing.
Thanks, sir. All right, Mr. Schmidt, who are you ready on?
I'm ready on Tyler, Germany.
Tyler Young, Germany, CR 18203. Go ahead, Mr. Schmidt.
Judge, we'd like to set Mr. Germany for a plea on that May 30th docket.
Is there any reason we can't do it sooner than that?
Oh, how soon is the court suggesting?
Thursday?
I can't do it on Thursday. I'm not prepared to appear in 294th District Court, but if the court wanted to set him sooner than that, then yeah, we could do that.
What about May 16th?
May 16th, is that a Tuesday, Judge?
No, sir, it's a Thursday.
I suppose so.
All right, court sets Mr. Germany to enter his plea on May 16th at 1:30.
Zachary Wooten.
CR 22-55-56, State versus Zachary Taylor Wooten. Go ahead, Mr. Schmidt.
We set Mr. Wooten for a plea on that May 16th docket.
All right, court sets Mr. Wooten for plea May 16th at 1:30 in each case.
Daniel West.
Daniel Keith West, CR 2381.
Same announcement, plea on May 16th.
All right, court sets Mr. West for plea on May 16th at 1:30.
Dugan Toms.
Dugan Lee Tom, CR 22158. Go ahead, Mr. Schmidt.
Oh, okay. Judge, we're set on a motion to adjudicate. I met with Mr. Hartwell last week. There is a matter of proof that Mr. Hartwell would ask of us that I think we could get for him that would resolve Mr. Tom's motion. And we'd ask for a reset to the May 30th contested docket date.
All right, court sets Mr. Toms for a final hearing on his motion on May 30th. Next,
Bobby Richmond.
Bobby Joe Richards, CR 2134. Go ahead, Mr. Schmidt.
Judge set on state's motion, met with Mr. Hartwell last Friday. The state is reviewing, I believe, a new offense or new allegation pertaining to a new offense. We'd ask that the state have an opportunity to finish their review prior to proceeding, so we'd ask it to be set for that May 30th contested docket.
All right, court will set Mr. Richards for a final hearing on May 30th. Mr. Schmidt, do you need more time?
I don't, they're just grabbing my folks, Judge.
Okay. So let's see, you have left Miss Goss, Miss Kennedy, Miss Paul. Is that correct?
Correct, and Donald Ellis,
Donald Ellis, that's a writ.
that's correct.
Mr. Lowe, as soon as I wrap up Mr. Schmidt, then you and Mr. Lyons will be up. If y'all want to go ahead and sit at the table and start prepping, you're welcome to do that. Mr. Lyons, you can come on up, and Mr. Lowe's ready for you. Go ahead, Mr. Schmidt, if you're ready.
Separate arraignment on Kayla Kennedy, CR 24-00058. Ready to proceed?
All right, go ahead. We're on record, CR 24-58, State versus Caleb Michelle. Go ahead, Mr. Schmidt.
Judge, we received a copy of the indictment, sure stands the charges against her, name is spelled correctly. Waive formal reading and enter a plea of not guilty as for pretrial setting.
All right, the court finds that Ms. Kennedy has waived the formal requirements of arraignment. Court does enter her plea of not guilty into the record. Set this matter for pretrial hearing. Do you want to set that May 28th?
That'd be fine, Judge, yes.
The court sets Ms. Kennedy May 28th for pretrial.
Wendy Paul,
Wendy Marie Paul, CR 2352.
We'll recall Ms. Paul.
Okay.
Just have to see the record, so. Stephanie Goss,
Stephanie Lynn Goss, CR 2163.
Judge, this is our first appearance on Ms. Goss on the motion to proceed. We'd ask that be reset to that May 30th date.
All right, court will set Ms. Goss for the contested docket May 30th at 1:30.
No, no.
All right, court calls WR 24-20. Donald Ellis versus State of Texas. This a bond reduction? I read it.
This is a 17-151 writ.
All right, you're gonna call your client for the purposes of bail reduction.
Yes, sir.
All right, Mr. Ellis, if you'll raise your right hand, I'm gonna place you under oath.
You're right. There you go.
Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
All right, you can lower your hand, speak up loudly and clearly. Go ahead, Mr. Schmidt. You can put your hand down.
Okay, I'm gonna ask you some questions, all right? And they're gonna take you down to the courtroom. Your name is Donald Ellis, correct? Yes, sir. And you were arrested on these charges in what county?
I was arrested in Kaufman, Henderson County.
In Henderson County, was that January 14th, 2024?
Yes, sir.
And you've been in constant custody since that time?
Yes, sir.
Now, ultimately, you realize the state has indicted you on this case, correct?
Yes.
And they returned an indictment April 19th, 2024. You understand that?
Yes.
At the point in which the indictment was returned, you'd been in custody a total of 97 days. You understand that?
Yes.
Does that sound right to you? Those dates?
I've been locked up a total of 106 days today.
You believe it's 106 days as of today?
Yes.
And as of the date you were indicted,
I don't know
I'm
what
doing
day.
the math for you, but would you agree with me? You had been in 94 days at that point.
I agree with you.
And since you've been in, your bond has been set at $50,000. Have you been able to post that $50,000 bond?
No, sir, I have not.
And did you fill out an application of pendency with this court requesting a court appointed attorney?
Yes,
And you listed on that document whatever assets, money or funds or property you might have, is that correct?
yes,
And was that affidavit correct?
yes.
Has it changed since the day you submitted it?
No.
So at this point in time, do you have any assets in which to post a bond that is currently set at 50,000?
No, sir.
You understand that the state has 90 days in which to indict you. In your particular case, it's your argument to the court that the state did not indict you in a timely fashion, correct? Correct. You understand also that if the court grants your request for a personal cognizance bond, you will be under conditions of pretrial release. And you understand that would require you to report to the pretrial release office at least once a month, pay certain fees towards your court appointed attorney's fees, and abide by other conditions. Are you aware of that?
Yes, sir.
Are you able to follow those conditions?
Yes, sir.
Are you, now that you're indicted, you understand that you'll have to come back and forth to court, most likely at least once a month until your case is resolved. Do you understand that?
Yes, sir.
Do you have transportation and the ability to get back and forth to court?
Yes, sir, I do.
And if the judge grants you relief, where will you be residing?
At my mother's house,
Where's your mother live?
Murchison, Texas.
Murchison, till you have an address in Murchison?
Yes. I don't know it offhand. I know it's up a Wildflower Road in Murchison.
Okay,
Uh,
but you will be able to get back and forth to court from Murchison. I don't know how far Murchison.
it's 20 minutes.
20 minutes, okay. I'll pass the witness, Judge.
State.
Thank you, Your Honor. Good afternoon, Mr. Ellis. So you state that you have been, you were advised that you were indicted, correct?
Yes, sir. I just got the letter 2 days ago. I was informed.
Okay. Now, where will you be working if you are able to make bond?
I'm going to be working for my mom part-time, and then I'm going to try to get back at my old job, doing 7-Elevens, the bollards.
What is your mom, what kind of business does your mom have?
She runs the Dallas Morning News newspaper routes.
Okay, and how long has your mom lived in her home?
Oh. I can't quite tell you. I know it's been about 10 years or more.
Okay, but you don't know the address, sir?
No, sir.
How many times did you say you've been over to visit her?
Quite a bit. I can't remember the number of it. She always has a PO box. I know it's off of Wildflower Road.
And what amount of bond could you make, Mr. Ellis?
I mean, I do not have a job at the moment, so I couldn't tell you. $0.
So how are you gonna pay for all your fees then, if you don't have any money to your, that you have access to?
Cause I've been locked up for 4 months, almost 4 months. So with that, I don't have a job. As soon as I get out, I will have a job and I will be able to make my payments.
And what's the name of the company that you'll be work for in addition to your mom?
Now I can't say that's going to be a total, so I mean, it's called Titan Retail. They're out of South Lake.
All right, thank you.
I don't have
Pass
an
the witness,
address
Your
for
Honor.
that.
Anything further, Mr. Schmidt?
No, sir.
Anything further from state?
No, Your Honor.
And Mr. Schmidt, when did your client say that he was arrested?
He was arrested in Henderson County on this warrant, January 14th, 2024. RGL shows him booked in January 17th, 2024. The indictment was returned April 19th, 2024. And based on our book in to the indictment return, that's 94 days. But if the out of county edition is what he's talking about, it would be longer than that.
All right. And Mr. Schmidt, do you want an argument?
Judge, I would argue on the motion that state 17-151 is fairly clear. This defendant is indigent and with an inability to post any sort of reduced bond. He is indicted, so we will proceed with the court case, but he was indicted post 90 days. So we'd ask the court to follow 17-151 and grant Mr. Ellis a PR bond.
Any response from state?
If I may, Your Honor, just in light of taking into account the fact that the allegation is that of arson. And I believe that a review of the affidavit that was proposed here for the arrest warrant alleges that this arson happened in the middle of the night, which is one of the most dangerous times, especially in a motorhome community or when people are sleeping. Those are the allegations, Your Honor. It's a very, very serious charge. And we'd ask the court to take that into account in actually setting a bond, and believe that a PR bond would just not be appropriate under these circumstances.
Mr. Schmidt's arguing that the law entitles Mr. Ellis because he was not indicted within 90 days. And he's testimony for the court is that he's indigent, doesn't have any money. So the court must follow 17-151 and either A, release him on a personal recognizance bond, which has no association with money, or B, lower the bond amount to something that he can make. Do you have a legal argument as to why he's not entitled to be released on a personal bond?
No, I do not, Your Honor.
All right, then the court finds that Mr. Ellis was not timely indicted. Therefore, Article 17-151 of the Texas Code of Criminal Procedure entitles him to be released on a personal bond. The court will set personal bond at $50,000.
Thank you, Judge. Thank you, Your Honor.
And Mr. Ellis, you're going to have to sign your conditions of pretrial release before you are released from custody.
Yes, sir. Thank you, sir.
Yeah, real quick. These are going back.
Yeah, they can go back. The judge's gonna rule at the end of the day, so I don't know. All right. I think I'm missing. I know that's a problem.
Your Honor, I'll be just a minute.
I'm ready on this.
Oh, I'm sorry. He's already ready. That was a short minute.
All right, Wendy Marie Paul, CR 2352.
Correct, Judge. Judge, state is, we agreed, they're filing a motion to withdraw state's motion to adjudicate and continue Ms. Paul on community supervision. Do you have that documentation,
I
Judge?
do. I do.
Ms. Paul's reviewed those amended conditions and has signed those today.
And is this for a continuation on community supervision, or does this terminate or extend?
Continue.
Continue? Okay.
Yes, sir.
And probation, it has reviewed this agreement and is supportive?
Yes, sir.
Yes, sir.
All right, Ms. Paul, if you'll raise your right hand, I'm going to place you under oath and ask you some questions, sir. I'm sorry, ma'am, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right.
Yes, sir.
All right, you can lower your hand. All right, Ms. Paul, you've heard the agreement in which the state is willing to dismiss their motion to adjudicate upon you serving 167 days in the county jail as a condition of your community supervision, for which they will give you credit for the time that you've already been in jail. You understand that if in a later time the state files another motion, if you are subsequently your community supervision is revoked and you're sentenced to any amount of jail or prison time, that you would not be entitled to this 167 days. You do understand that?
Yes, sir.
Okay. And understanding that, do you still wish to go forward?
Yes, sir.
Has anyone threatened, forced, or pressured you to enter into this agreement?
No, sir.
Are you pleased with Mr. Schmidt and the legal work he's done for you?
Yes, sir.
All right, then the court will grant the state's motion to withdraw, the motion to adjudicate. The court amends the conditions of Ms. Paul to include 167 days confinement in the county jail as a condition of community supervision. And the court does give her credit for the dates served between August 4th, 2009, November 4th, 2019 through February 4th, 2020. And also for that period served between February 16th, 2024 to today, or to yesterday, April 29th, 2024. The court hereby continues Ms. Paul on community supervision.
Thank you, Judge.
Thank you.
Thank you, Mr. Schmidt. Is that all you have, Mr. Schmidt?
That should be all I have, Judge.
One of them sitting there.
Hey, Your Honor, we will see you back at the courthouse.
Thank you, Sarah. Give my court reporter just a short break. Sure. And then she's gonna come right back in, so. Okay. So as soon as she comes back, we'll be ready. If you need a break, go for it. Okay. Yeah. Step out for a moment. We'll get started.
Next thing. Yeah. Good.
I didn't.
Yeah, it's next to impossible. Whether you're there with someone or you're there by yourself, obviously they wake you up constantly. How soon is the therapy supposed to start? Still up in the air.
First you have to have an exam, then you have to have an evaluation, then you have to do this, then you have to do that.
Jeez.
He wasn't supposed to come home. He was supposed to go to inpatient. But some hospitalist doctor came by on Saturday, pulled out his drain tube and said, okay, I've written your discharge order.
Very good.
right, please be seated. All right, we are on record, cause number CR 23-221, State of Texas versus Jonathan Lee Lyons. We're here today, Mr. Lowe, on Mr. Lyons' amended motion to suppress, correct? All right, you ready to proceed? Go ahead.
Do I need to furnish the court a copy of my amended motion?
I actually just printed that out.
I did file it, he filed it so that the state has a copy. So we'll call Sergeant Wheeler.
All right, Sergeant Wheeler, if you'll come forward. All right, sir, if you'll raise your right hand, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth? So, what's your step? Have a seat. During your testimony, it's important that you speak up loudly and clearly. Allow the attorneys to finish their questions before you give an answer, so that we're not talking over one another. Or so there's an emergency vehicle or a loud truck, something that makes it hard to hear, just stop testifying with the court. Let that pass so that we can all hear you. Also, if an attorney stands up and objects, allow them to finish their objection, stop testifying. Court will then rule on it and let you know if we go forward. Okay. All right. Mr. Lowe.
Thank you, Your Honor. So before we start though, I think there's already a search warrant affidavit filed. Why didn't you give you another file?
No, court will take judicial notice of the exhibits that were admitted in the last hearing.
Thank you.
If you'll just make sure to turn your microphones on.
It's not on.
No, red is off, green is on. You just hit that button until it turns green.
Oh, okay, excuse me. I'm sorry. Sorry, Judge. Oh, both of them.
Just, there you go.
Okay. Better, Judge?
Better.
All right, so, thank you, Your Honor. Afternoon, Sergeant. Afternoon. I'm Doug Lowe. We have not met before, is that right? No, sir. We talked on the phone yesterday, but not about this case. We talked about our gambling prosecutions we used to do. So, tell me a little bit about your education, training, and certifications that you have.
I graduated in 2000 from Wills Point High School. Graduated the East Texas Police Academy in 2009, and I've had several continuing education classes since then.
Right. What classification of peace officer license do you hold?
Intermediate.
Intermediate. How far are you away from your master's?
I couldn't tell you that exactly on the hours.
Okay, so with regarding to your training, have you done specialized training with regard to drug investigations, search warrants, those kind of things?
Yes, sir. That's mainly what I work is narcotics.
Right. About how many hours do you have?
Training.
Yes, training for certification or related just to search warrants, drugs, those kind of things. I'm not talking about gambling or anything else.
Right. I've been to a couple of search warrant classes that were, I can't, for sure, 2, maybe 3-day classes each. I don't remember exactly what they were. I've been to interdiction classes and covert operation narcotics classes, and
So I would characterize you as having a fair amount of education just related to drug cases and also applications for search warrants. You're very familiar with the law and what you have to do. Is that a fair statement?
yes, sir.
All right, so the subpoena that you were served had a ducis tecum, which means you were supposed to bring records with you. Did you bring the records?
Yes, sir.
And I assume that there's some confidential documents in there. Would that be a fair statement?
Some confidential documents? No, sir.
Or no? So nothing related to the confidential informant, anything like that?
No, sir.
Okay, so could you just describe what you brought then as far as?
I brought the photographs from his residence that day. I brought the search warrant and affidavit and my report that I did on it,
Okay,
or supplement.
okay, so you did supplement. You don't have your, and I apologize, your mama liked the D names, your sisters.
Yeah, she did.
I apologize about that, not knowing that you guys were brother and sister. All right, so let's talk then about just generally about search warrants, if we could for a minute.
Would you agree that, as to the importance of providing the judge with reliable and verifiable information? Would you agree with that? Yes. And the reason for that is so that the judge can make a decision regarding probable cause before he issues a search warrant. It's important. Yes, sir. All right, and you know for sure that you cannot provide the judge with any false or incorrect information. You know that, right? Yes, sir. And if there is evidence of a false information, then we would be entitled to what's called a Frank's hearing. You've heard of that Frank's hearing before? Yes, sir. All right, so I will tell you at this time, we're not alleging a Frank's violation. But let me ask you, do you know of any false or incorrect information that you used in the preparation of the search warrant affidavit? All right. All right, so let's look then at the search warrant, if you could get it out, or I can give you a copy if you need to have a copy. I brought a copy. And Your Honor, I think it's marked as exhibit number 1. So for purposes of the record, we could have, just make sure that's exhibit number 1.
I have affidavit is S1, states 1, arrest warrant as S2, states 2, and then photo is D.
Okay, so the affidavit is S1 then?
Yes.
All right, so Sergeant, we're gonna be referencing states 1, which is your search warrant application that you prepared, correct? Yes, sir. All right, so let's talk first, just generally about the first paragraph. So if we could look at the first paragraph, it starts out, the date was September the 3rd. Agree with that? Yes, sir. All right. And essentially this first paragraph talks about how your sister was involved in the investigation of an allegation where some people, including Mr. Lyons, allegedly delivered methamphetamine to a juvenile by the name of Adrian Turner. Yes, sir. And it starts out where he was found passed out in his mother's front yard. Right? Yes, sir. And let's do this. Would you read the very last sentence of that paragraph that starts with Adrian? Would you read that for the record, please? Adrian was transported to the Kaufman Presbyterian Hospital by EMS to be evaluated. All right. So in the second paragraph, September 5th, 2023, Detective Wheeler, that would be Dawn, right? Yes. And I think you go more commonly by investigator or sergeant. Yes, sir. And she goes by detective. Yes, sir. Okay. All right. So back on that last sentence, Adrian was transported to Kaufman Presbyterian Hospital by EMS to be evaluated. All right. So the essence of this case then is that there was a person, Adrian Turner, that was alleged to have received some methamphetamine from Jonathan Lyons. That's the essence of this case, right? Yes, sir. All right. And so you did your search warrant on September the 6th. Your search warrant affidavit on the 6th. Yes, sir. All right. Now one thing that that's not anywhere in referenced in here is medical records from Presbyterian Hospital. You agree with that? Yes, sir. All right. So let's pretend then that I'm the judge, and I'll never be a judge, but let's pretend, okay? So we're talking about your search warrant affidavit, and the judge says, what this case is about giving a child methamphetamine. Judge says that. You say, yeah, that's what it's about. Well, how do you know it's methamphetamine? Oh, sorry. Personally, I wasn't there. I couldn't tell you if it was or wasn't. Well, but you're the affidavit, and you know that you've got to give some judge a reason to issue this, because as far as being American citizens, that's the sanctity of our home. The issuance of search warrant, that's a radical thing when you get a search warrant for somebody's house. So the truth is, there's nothing in this search warrant affidavit about verification that this person had ingested methamphetamine. Right? Yes, sir, you're right.
But that could have been done. It'd been easy. Call over there to the hospital and say.
Objection, Your Honor, that's not relevant. What could have been done is not relevant. What's relevant for the court to look at is what was done and to determine if that amounts to probable cause.
I'll move on, Your Honor.
Court will sustain the objection.
So, so as far as any proof that this person ingested methamphetamine, all you have is his word. At the time you wrote this affidavit, according to the affidavit, that's all you had.
From that part of it, yes.
All right. All right. So, let's go down to, September 5th on the bottom paragraph, Sergeant Hughes. Who's Sergeant Hughes, by the way?
He's a canine officer for Wills Point Police Department.
All right. And you used his information as probable cause to show that there was something bad going on at that address, 430 North U Street, right? North Wills Street.
Yes,
Sorry.
sir.
All right. But looking at the affidavit, there were no arrests, according to the affidavit, there were no arrests made. There was no investigation done by Sergeant Hughes. There was no seizure of any drugs. Right?
I couldn't tell you if he seized any that night or not.
Well, because the district attorney is exactly right. We're talking about what's in this affidavit. The four corners is what we're talking about. And we're trying to make sure that you give, as the affiant, enough information for probable cause. So as far as Sergeant Hughes, according to what you wrote, we can glean from that there was no investigation, there was no arrest, no testing of the drugs, and apparently the drugs, there was something thrown on the ground. But we don't know what was in it, right? So that's just really not very helpful. You agree with that, right?
Yes, sir.
All right. So let's go to the second page, talking about your confidential informants. And there has been lots of litigation on the confidential informants. You know that, right? And I think based on what
Objection, Your Honor. Could I ask what he's referring to? I don't see anything that says confidential informant.
Do you have any document that you're referring to that provides confidential informants?
Oh, well, based on the representation the state made last hearing that this person that he used was a confidential informant. If that's not true, then they can disclose who it is. But you remember we had quite a bit of discussion last time about identity of the confidential informant. This person that's referenced in that paragraph.
And it's a source of information, which is very different from a confidential informant. There is no confidential informant.
Well, I'm shocked because we had a big discussion last time that this was a confidential informant.
No, we had a discussion about Dawn Wheeler and Dawn Wheeler's confidential informant. This is David Wheeler's source of information.
Okay. So I'll move on, Your Honor. So you didn't put the person's name in there then. You said he, she. You referenced this person in next paragraph, it's he, she. You didn't put the person's name, did you?
No, sir.
So that's a confidential informant?
It's a source of information.
Okay, it's a source of information. You tell me who it was. Tell me, if it's just a source, just tell me.
Objection, Your Honor. It's not about who it was. It's about what's contained in the affidavit for the court to determine if there's probable cause.
He's entitled to the information, so the court's going to overrule it. So you can answer his question.
I don't want to tread on confidential informant. This is a whole separate thing. And I apologize.
Well, it's okay. It's been made clear that it's not a confidential informant. And so if it's a cooperating individual, then that's information that the defense is entitled to it, whether you get it in discovery or you get it in a motion suppress hearing is irrelevant. You're entitled to it. So I've directed the witness that he can answer that question unless you're withdrawing the question.
No, I think it's not stated in here, but I would like to know, so I'll let the question stand for itself.
This is Roy Mitchell.
Pardon me?
Roy Mitchell.
Roy Mitchell. Okay, he's one of the residents of that house?
No, sir. I don't believe he's a resident.
Okay. All right. All right, so as far as the source of information, you don't have anything in here regarding whether or not his statement could be trustworthy. Would you agree with that? You don't say anything after the truth? I'm sorry.
I'm sorry, repeat, say it one more time.
So let's talk about the trustworthiness of this person, that you didn't tell the judge who it was. You didn't tell the judge. You said-
Objection, Your Honor. Relevance, trustworthiness of the person is beyond what's reflected in the warrant, is not relevant to today's hearing.
I'm gonna overrule the objection. If this officer has based information from the cooperating individual and that becomes the basis of what he is swearing to in the affidavit, I think it's relevant. So you can answer the question.
Say it one more time now.
Okay. I think I may have forgot what it was. So,
He asked you about the trustworthiness of your confidential, or your source of information, your cooperating individual.
so let me try to restrain that, okay? So
Okay.
in the affidavit, you did not say anything that would give the court, the magistrate, confidence about the trustworthiness of the cooperating individual. True?
True.
All right, so we don't know, at least from the affidavit, you didn't say he was a good citizen. True?
True.
You didn't say he was worthy of belief. True?
True.
You didn't say this person had gainful employment. True?
True.
And you didn't say that this person had given you information in the past. True?
True.
All right. So, let's talk then about the information this cooperating individual gave to you. And we're gonna talk about the freshness of the information, okay? Whether or not, you know what I mean by stale or fresh information in terms of drugs? All right, so you know what a trap house is, right?
Mm-hmm.
All right. That's where they're regularly engaging in selling drugs, all right? And if we skip down to the last paragraph, where it talks about his continued involvement. All right, but that almost sounds like a trap house where people are coming in and out at all hours. Right?
When you answer, you have to.
Oh, yes, sir. Yes, sir.
All right. And so, the sentence, you say here that, the paragraph that I'm talking about says the source was asked if he or she was at 430 North Will Street. That paragraph right there.
Okay.
And this cooperating individual, Roy, says that he saw the juvenile, Adrian, smoking methamphetamine. Right?
Yes, sir.
It doesn't say that Mr. Lyons supplied the methamphetamine to that juvenile, does it? Didn't say that.
That's correct.
All right. And then, the next paragraph, the source was asked when the last time she had seen Lyons with any narcotics. The store stated that approximately 2 weeks prior to the event, he had purchased methamphetamine from Lyons at the same residence. Okay? Right. Now, you'd expect though, if this was, as you described it in the last paragraph, there would be people there that were in and out of that house daily, not just 2 weeks in advance, right? You'd agree with that? Yes, sir. All right. So you understand that one of the things the search warrant has to do is establish that the objects that you're searching for is going to be present when you search. Yes. And the information needs to be fresh. Yes, sir. Now, you'd agree with me that 2 weeks is not fresh information. 2 weeks, no. That's not fresh, is it? No, sir. All right. So let's talk about conclusions that you made, right? And so the last paragraph, I think is basically your conclusion about Mr. Lyons' activities. Can you, do you want to look at that last paragraph? It's pretty much your conclusions. And you understand that because you believe something, that's not probable cause. You agree with that? Yes, sir. That probable cause has to be based on facts, not just mere speculation. Yes, sir. Right? So you know that if on a drug case where you're looking at a trap house or where there's lots of stuff going on, the way to do that is to do a proper investigation. You agree with that? Yes, sir. You do surveillance, right? Right? Yes, sir. You know, we used to use pole cameras over in Anderson County. You could just put a pole camera. All right. You could look at the arrest of other people around related to this house, right? You could have looked at the arrest. Yes, sir. You could have made a control buy, right? Establish probable cause. You could have got phone records, right? Yes, sir. You could look at people's Facebook, right? Because it's crazy to me how these people put pictures of their dollar bills on Facebook. You didn't do any of that. Come to this conclusion, did you? You didn't do any of that. No, sir. So this last paragraph is just your belief what's going on in that house, right? That's what you believe. Based on what's in the affidavit, yes, sir. Well, there's none of that stuff in this affidavit. There's none of that kind of stuff that substantiates a first-class investigation. This is just, and I'm sorry, Sergeant, this is just you saying, I believe this is going on. My goodness, I'll go get a search warrant. Right? That's your opinion on that one, sir? Well, no, my opinion don't matter. This is just what you believe is going on. There's no substance that's indicated in the four corners of this affidavit about to justify your conclusion. True? I believe there is, yes, sir, based on facts in the affidavit. All right. Okay, let's talk about, I'll try to wrap this up with talking about the location, your where you asked to be searched. All right. The pictures that I've seen, and you've got the originals, right? The pictures that I've seen of this house at 430 North Wills show two different structures. House, there's a garage, right? Yes, sir. Right. Now your search warrant did not ask for curtilage. You agree with that?
Um,
And I will take you over too. That's actually, you said, I request, this is the bottom of that page. I request a search warrant for the following place: 430 North Will Street, Wills Point, Texas. You didn't ask to search that garage, did you?
I asked to search the address of 430 North Wills,
Well,
which the garage is located at that address.
but it's two different structures though. You agree with that? You took the pictures. You agree it's two different structures?
Would I agree it's two different structures?
Yes.
Yes, sir.
And you didn't ask to search that garage.
Specifically the garage? No, sir.
And you didn't ask to search the curtilage.
I believe the curtilage was added onto the warrant itself, not the affidavit.
Well, but I'm not talking about that yet. I mean, the judge may have allowed that, but you didn't ask for that in your affidavit.
No, sir.
All right. So, you had your sister's report, right? You had your sister's report?
Yes, sir.
In fact, she had indication, she knew exactly where those drugs were supposed to be, if there were any.
I suppose so. Yes, sir.
You could have put that in this affidavit, and you didn't, did you?
No, sir.
And the reason that she, I think, that you do this affidavit is you're more experienced in the drug business than she is.
Yes, sir.
I'll pass the witness, Your Honor.
Thank you, Judge. Sergeant Wheeler, were you the lead officer in this case?
I was not the lead officer, no, ma'am.
Even though you were not the lead officer, or when you're not a lead officer and you're called upon to assist with a warrant, is it common for you to talk to the other officers, review their reports, gather information from various sources to go into a search warrant affidavit?
Yes, ma'am.
And is that what you did in this case?
Yes, ma'am.
And by the way, is Mr. Lyons charged with running a crack house?
No, ma'am.
What's he charged with?
Possession
And
of substance.
and specifically for this case, is he charged with delivery to a minor?
No, ma'am.
What the case you were working on was the possession case. Is that what you're saying?
The search warrant was the possession case.
Okay. Sergeant Dawn Wheeler, does she have a delivery to a minor case?
Yes, ma'am.
Okay. And when you began gathering information for this search warrant, I assume you talked to Sergeant Dawn Wheeler.
Yes, ma'am.
Okay. And let's go through this warrant kind of paragraph by paragraph like defense counsel did with you. So looking at that first paragraph there, it indicates also that Officer Bocook was involved. Do you see that?
Yes, ma'am.
And based on what you were told and what you reviewed in the other reports, did it appear that Officer Bocook, or did you include in the warrant affidavit that Officer Bocook observed Adrian Turner to have overdosed, laying in the front yard, or at the time he's laying in the front yard of his mother's residence?
Yes, ma'am.
All right. And was EMS called for him?
Yes, ma'am.
All right. And at that point, did Adrian Turner tell anyone where he got the meth from? What
Section
location?
Overruled.
What location he got?
Objection, hearsay.
Overruled.
In your affidavit, does it reflect that Mr. Turner told one of the officers what location he got the meth from?
I believe Adrian's mother told Officer Bocook.
And what was the location?
It was 430 North Wheels.
Okay, so in paragraph 1, we have someone saying that this minor ingested meth at 430 North Wills.
Yes, ma'am.
And did the minor, based on your conversations and reviewing reports with the other officers, did the minor appear at that time to be under the influence in a state of overdose?
What he talked about, investigation with an officer. That's outside the reports of that check.
Sustained.
Does your affidavit indicate that the other officers observed him to be under the influence or in a condition of overdose?
Whenever he arrived on scene and he was laying in the front yard.
And I believe defense counsel already pointed out that he was transported by EMS to the hospital, according to the affidavit. Is that correct?
Yes, ma'am.
And if you look at the go up about 4 lines from the bottom of that first paragraph, I'm going to read here from your affidavit. If I get it wrong, you tell me, okay? Adrian advised Officer Bo Cook that Catman Lyons, which is Jonathan Lyons, Little Roy Mitchell, which is Roy Mitchell, and James Covey provided him with the ice. Is that what's reflected in the affidavit?
Yes, ma'am. That's correct.
So in your affidavit, paragraph 1, the minor says there's ice at 430 North Wills. Correct?
Yes, ma'am.
All right. So paragraph 2, 2 days later on September 5th, the minor's mother reaches out to, according to your affidavit, reaches out to Detective Dawn Wheeler. Is that correct?
Yes, ma'am.
And says, hey, my son's ready to come in and talk. They make arrangements to sit down and visit. Is that correct?
Yes, ma'am.
And at that point in time, Adrian advised that he had been smoking methamphetamine and Catman gave it to him. Is that correct? Looking at the last couple lines there.
Yes, ma'am.
All right. So again, in the second paragraph, and by the way, before all this, did you know who Catman was?
Yes, ma'am.
Did you recognize that nickname?
Yes, ma'am.
That's outside the full warrant, what is that, there's objection.
I'll withdraw the question, Judge. So in the second paragraph, we again have Adrian saying that he got the meth at 430 North Wills. Is that correct?
In the second paragraph?
Or that he got it from Catman?
Yes, ma'am.
Okay. All right. Third paragraph. I think you already told us Sergeant Hughes is referring to Charlie Hughes with the Wills Point Police Department. Is that correct?
Yes, ma'am.
All right. He's Sergeant Hughes is a patrol and interdiction officer. Is that right?
Yes, ma'am.
Okay. So the information that you put in the affidavit indicates that on September the 5th, Sergeant Hughes encountered 2 individuals who were seen leaving that same residence at 430 North Wills. Is that correct?
Yes, ma'am.
All right. And one of those individuals was in possession of a meth pipe.
Yes, ma'am.
Your Honor, I don't think it mischaracterizes the testimony, what's in that, it looked like a meth pipe. Objection.
Or will sustain the objection.
All right. One of those individuals had a pipe that looked like a meth pipe. Is that correct?
Yes, ma'am.
And on the ground, near those 2 individuals, Sergeant Hughes found a baggie with a small amount of methamphetamine. Is that correct?
It's the big cars, what's in there. We don't know if it's methamphetamine from what this affidavit says.
Your Honor, the affidavit refers to it as methamphetamine. I'm going over what's in the affidavit.
Overrules the objection.
Thank you.
So is that correct? There was also in proximity of the two individuals on the ground, a small baggie of methamphetamine?
Yes, ma'am.
And Sergeant Hughes noted when you got the information from him that that baggie had not been there at first, but sometime during the encounter was put on the ground in some manner.
Yes, ma'am.
So then on to the next paragraph, where you, Investigator Wheeler, met with the source of information, and we know that's Roy Mitchell. Is Roy Mitchell a co-defendant in this case?
Yes, ma'am.
Now, Sergeant Wheeler, or I'm sorry, Investigator Wheeler, a confidential informant, are there special requirements of you when you engage a confidential informant in an investigation?
Yes, ma'am.
You have to open a CI file, you have to give them a number, you have to sign an agreement, you have to do a lot of things, correct? And that enables you to do what with that person?
It enables me to do undercover controlled narcotics purchases or.
Your Honor, it's relevant to the subject matter that was brought up by defense counsel, that this investigator does know the difference between a CI and a source of information, and that the source of information here is not mislabeled when it's not called a CI.
There you go.
In this case, did you use Roy Mitchell in any of that capacity as a confidential informant?
No, ma'am.
So you refer to him here as a source of information.
Yes, ma'am.
Is that a common term that you use for people you talk to, but don't sign up as a CI, as we call it?
Yes, ma'am.
And in the affidavit, you go over what Mr. Mitchell told you. And in the 2, 3, I guess the third paragraph on that second page, it says that the source was asked if he or she was at 430 North Wills when Adrian Turner, who is a juvenile, ingested the narcotics into his body and later needed medical attention. The source stated he was there and saw Adrian smoking methamphetamine. So again, we have another person saying that there was methamphetamine at 430 North Wills. Is that correct?
Yes, ma'am. That's correct.
Okay. And that would have been during the time period that Adrian Turner was there, which was approximately September the 3rd. Is that correct?
Yes, ma'am.
Because September the 3rd is the day that he was found overdosed in his mother's yard.
Yes, ma'am.
Then some additional information there. Mr. Mitchell goes on to say that prior to that, he had in fact himself bought methamphetamine from Mr. Lyons, and that was about 2 weeks ago.
Yes, ma'am.
Okay. So in that paragraph, Mr. Mitchell puts methamphetamine at 430 North Wills about 2 weeks prior.
Yes, ma'am.
Now, in writing search warrants, in your experience, if the only information you had was information that there was methamphetamine in a location 2 weeks prior, would that likely be sufficient to get the search warrant?
No, ma'am.
Overruled.
And additionally, if in writing a search warrant affidavit, the only information you had was information from a confidential informant, in your education experience, does the information, if that's the only information in the warrant, in the affidavit, does that information need to be, does the affidavit need to say that that person is truthful and reliable and how you know that?
Yes, ma'am.
In this warrant affidavit, is the information from Roy Mitchell a source of information, the only information that you had in this affidavit?
No, ma'am.
When Roy Mitchell told you these things, was Roy Mitchell doing it against his own penal interest as well? Against his own criminal interest as well?
No, ma'am.
He placed himself at the house where the methamphetamine was being used.
Oh, yes, I'm sorry.
Okay.
Yes.
Now, let's talk about that house, sir. And do you have a copy of the actual warrant there, not just your affidavit?
Yes, ma'am.
All right, and on the warrant page, third paragraph, you are commanded to enter the suspected place, curtilage, vehicles, and premises described in said affidavit, to wit, 430 North Will Street, Wills Point, Texas, 75169. To the best of your knowledge and belief, the garage that, well, first of all, did you search the main residence?
Yes,
In,
ma'am.
okay,
Outside of the doors of the church.
I'll move on, Judge.
Sustained.
And the garage that was searched, well, let me ask, did you search the garage that day?
Yes, ma'am.
And that garage, does it have any address to the best of your knowledge other than 430 North Wills Point, Texas?
Outside the 4 corners.
Sustained.
Was everything you searched, every building you searched that day, did it have an address of 430 North Wills?
Checks in the 4 corners.
Overruled. That's to that question. You can answer that question.
Yes, ma'am.
You filed an inventory in this case after the search warrant, as you're required to do. Is that correct?
Yes, ma'am.
And I believe, if I recall correctly, the inventory listed 4 items. Hydroxyzine, less than 1 gram meth, gabapentin 300 milligrams, and trazodone. Those the items that you seized from the residence, the garage,
Yes.
building that day? I pass the witness, Judge.
Mr. Lowe, your witness.
Thank you, Your Honor. All right. Let me get this straight. Talking about paragraph. Source of your information on September 6th. Source was asked if he/she. That's what it says, right? I'm not keeping you up, am I?
I'm sorry.
You're yawning. I'm not keeping you up, am I?
No, you're good.
Okay. It says he/she, right?
Yes, sir.
Doesn't say Roy. You didn't tell the judge that this person is the same person that was identified on page 1. You said he/Lee. I'm curious. Is he bisexual or something or what?
No, sir.
Or
No, I mean, I can't say that he is or he's not. I don't know.
That's the wrong word. It's not bisexual. It's something else. The state legislature just outlawed it. So anyway, all right. He/she. You didn't say this is Roy. And I would say this is a curiosity to me, why you didn't say Roy. Okay. All right. It's fundamental in search warrants law in Texas. You've got to tell the judge what offense you were searching for, right? And you just told the district attorney that.
Objection, Your Honor. That calls for a legal conclusion. That's not appropriate for this ordinance.
Sustained.
Okay. You tell me one more time, what offense you say did the search warrant affidavit for?
Objection, Your Honor. Relevance.
Your Honor,
Overruled.
what offense were you saying had happened? Don't look at that. You tell me what you told her.
The offense that had happened was the delivery.
Okay, now that's not what you said a while ago. You said you did a search warrant affidavit for possession.
Judge, he's mischaracterizing the testimony. Objection. Search warrants can be issued for offenses that already occurred, or they can be evidentiary search warrants to look for evidence of offenses that have not been detected. He's trying to twist it around here.
So let's look at the affidavit. Since we're stuck with what's in the affidavit. Look at the third page of your affidavit. It says section 841.122. You read into the record what the offense you wanted to search warrant for. Just read it in the record.
It said offense delivery of a controlled substance or marijuana to a child.
So it wasn't possession. True? There's a difference between possession and delivery.
You're correct. Yes, sir.
It wasn't for possession. This is what you were searching for. All right. I'll pass the witness, John.
It's great.
Can I have just a moment, Your Honor?
Right.
No questions, Your Honor.
All right, let me step. What's your step?
We rest on the motion.
Right. Any rebuttal?
No, Your Honor, just argument.
Just like argument, Mr. Lowe?
You know, Your Honor, I put argument too much in my motion, so I'll stand on what I said in the motion.
Okay, thank you, Mr. Lowe.
Then I'd like to respond, Your Honor. In his motion, if I could get it up here, Judge. In his amended motion to suppress, Your Honor, Mr. Lowe relies on Illinois versus Gates, which is confusing to me. He relies on Illinois versus Gates when he asserts that the person drafting the probable cause affidavit must demonstrate to the magistrate that the unnamed informant is credible and reliable. However, Illinois versus Gates is the case where that in fact was overruled by the Supreme Court of the United States. And they held that the rigid two-prong test under Aguilar and Spinelli that had been in use for several years for determining whether an informant's tip establishes probable cause for issuance of a warrant is abandoned, and the totality of the circumstances approach that traditionally has informed probable cause determinations is substituted in its place. The elements under the two-prong test concerning veracity, reliability, and the basis of knowledge should be understood simply as closely intertwined issues that may be useful to illuminate a common sense practical question as to whether there is probable cause. So there is no longer that rigid requirement that it must be recited that an informant, or if you extend that to a source of information, that their reliability must be set forth in the affidavit. That was abandoned by the court in Illinois versus Gates for a totality of the circumstances approach. Additionally, in his motion, Your Honor, he quotes after that, he says the affidavit must state facts that establish that the individual is a good citizen worthy of belief, information such as gainful employment, lack of criminal history. And he goes on through this laundry list and cites to Bella versus State from the Texas Appeals Court out of El Paso in 1982. The problem with that quote, Your Honor, is that Illinois versus Gates was decided just a few months after that Court of Appeals decision. And when the Bella case went up to the Texas Court of Criminal Appeals, they noted that now there is the intervening opinion of Illinois versus Gates. So the logic and reasoning of the Court of Appeals in Bella was set aside, and the Court of Criminal Appeals reinstated the trial court's ruling on the issue of the motion to suppress. So that quotation there is from a El Paso Court of Appeals case that has been since overruled by Illinois versus Gates. And when you take the totality of the circumstances approach from Illinois versus Gates, you look at this warrant and you break it down, or this affidavit, and you break it down, there are multiple indicators, not just one source of information. There are multiple indicators of the presence of methamphetamine, other controlled substances, delivery of methamphetamine to a minor that occurred at 430 North Wills. We're not here to decide whether it was done by Mr. Jonathan Lyons. We're here to decide whether there was probable cause that there was methamphetamine at 430 North Wills in Wills Point, Texas. When you take that totality of the circumstances approach, you can go from September 3rd, from time period before that, which the court can put little or no weight on, but you can start at September 3rd, September 5th, and finally the warrant is issued on September 6th, indicating that there is probable cause, not beyond a reasonable doubt. We don't have to have a lab report back. Probable cause that there would be methamphetamine at 430 North Wills. Your Honor can recall in the first hearing that we had that there is a house, there's a wooden sidewalk deck that appeared to be about the width of this table, and then the garage. Asking for a search warrant to search a residential address and having a warrant issued that includes all the curtilage, if there is curtilage on a residential lot. The buildings of the residential lot includes a detached garage. The search warrant was properly executed. It was executed at the address of 430 North Wills. The residence was searched, 4 items were taken. A totality of the circumstances approach tells us that there was probable cause for the court to issue the warrant.
Thank you, Mr. Craig. All right, court's going to take the evidence and arguments under advisement, and I will issue a written ruling and provide it to council.
Thank you, Judge.
You're welcome. All right, if there's nothing further in this case, we're adjourned. Thank you, Mr. Lowe. I appreciate your patience this afternoon as well.
Yes, sir.
Never know how evidentiary days are going to shake out. We prepare for a bunch of contested, and then that changes. So it's kind of tough to logistically figure those out.
I understand.
All right, do we want to get Mr. Manning? So we get going on Mr. Rodriguez's case. legacy. Mr. Rodriguez, if you'll come forward. All right, this is cause number CR 18-00503, State of Texas versus Josue Rodriguez. This is the state's amended motion to adjudicate and revoke. Mr. Manning, does your client waive the formal reading of the state's amended motion?
We do, Judge, just to clarify the record, this is the motion that was filed on September 5th of 2023. Is that correct?
Correct. All right, and Mr. Rodriguez, how do you plead to counts 1, 2, 3, 4, and 5? Are those counts true or not true?
Not true.
All right. All right, this is the state's motion. State, you ready to proceed?
Yes, Your Honor.
You may do so.
Thank you. Your Honor, state would ask the court to take judicial notice of the court's file in this case.
All right, court takes judicial notice of the filings in cause number CR 18-503.
And state calls Stephanie Clark.
All right, Ms. Clark, if you'll come forward. Clark, if you'll raise your right hand. You swear that the testimony you give to the court today is the truth, the whole truth, nothing but the truth, so help you God. Yes. Have a seat. Good, Mr. Manning. I'm sorry. Go ahead, Mr. Hartwell.
Thank you, Your Honor. Good afternoon, Ms. Clark. I'm sorry, Officer Clark. Can you tell me what it is that you do for a living?
I am a probation officer with Van Zandt County and I supervise sex offenders,
Can you tell me about what your duties involve with the sex offender caseload in Van Zandt County?
ensuring that they comply with their conditions of probation and reporting back to the court if they do not.
About how long have you been a probation officer with Van Zandt County?
With Van Zandt County
Mhm.
since 2008.
And did you have experience as a probation officer before that?
I did. I worked for Van Zandt County previously and for Hunt County as well.
So total years, how many total years do you have?
23.
I'm sorry,
23.
23. And of those 23 years, about how many years have you spent as a sex offender caseload
I
supervisor?
believe I took it over in 2010.
So it'd be fair to say 13 going on 14 years?
Yes, sir.
During your time, have you had the opportunity to supervise Mr. Rodriguez?
I did his intake and then transferred him to Henderson County.
And do you remember about what time Mr. Rodriguez was placed on probation?
He was placed on probation on uh 4/28/2022.
Do you see Mr. Rodriguez in the courtroom today?
Yes,
Can you describe what he's wearing and where he's seated?
he's wearing an orange jumpsuit with a white t-shirt underneath.
Your Honor, state asked the record to reflect that this witness has identified the defendant and probationer.
All right, record will reflect that this witness has identified the probationer and defendant in this case, Jose Rodriguez.
And Your Honor, may I approach the witness? Clark, I'm handing you what's been pre-marked as State's Exhibit 1. Can you identify what that record is?
This is his judgment and his conditions of probation when he's placed on probation.
And does that appear to be a certified copy?
Yes.
Your Honor, State offers States 1, the certified copy of judgment and conditions of probation.
Any objection?
Judge, if I may just have one moment, I have to check something.
Yes.
Okay.
All right. What was that, Mark?
States 1, Your Honor.
All right, there being no objection, then State's Exhibit 1 is admitted.
If I can have just a moment, Your Honor, I'll pre-mark a couple.
Okay.
And may I approach, Your Honor?
You may.
Officer Clark, I'm handing you what combined has been marked States 2 through 6. You recognize those documents?
Yes, sir.
And how do you recognize those documents?
And these are admission forms that probation officers use when people admit to using either drugs.
Sorry, hold on.
Objection, Your Honor. I'd like to take this witness on board,
For what purpose?
determine her basis of her knowledge for these documents.
Go ahead.
Officer Clark, are these the forms that you use in Van Zandt County?
It's not the exact form, but it's very similar.
And did you administer these forms to Mr. Rodriguez?
I did not.
Were you present in the room when those were administered?
No, sir.
Your Honor, I object to the witness not having personal knowledge of these documents and being able to testify to them.
I don't think he's offered them yet, but your objection is noted. I guess he has the right to try to rehabilitate whether or not she has personal knowledge.
Yeah, thank you. Ms. Clark, how did you come into possession of these documents?
And the officer in Henderson County sent them to me after the defendant signed the admission forms.
And do you recognize anything that would be the defendant's signature?
Yes.
How do you recognize that?
Objection, Your Honor. That's a opinion that this witness is not qualified to testify to.
Sustained.
Has this defendant ever signed anything in front of you that you would recognize?
His conditions of probation.
Does that signature on the conditions of probation seem to match the signature on those forms?
Your Honor, once again, I object. She's not been tendered as a handwriting expert.
Sustained.
After receiving the admissions, what if any action did you take?
I filed a motion to revoke.
Did you talk to Mr. Rodriguez?
Don't believe so.
Did you speak at all with the probation officer in Henderson County?
Objection, Your Honor, that answer calls for hearsay.
Your Honor, I'm just asking if they spoke, not what was said.
Overruled.
Again, Miss Officer Clark, did you speak directly with the probation officer?
I did. When she sent me these forms.
What process do you usually take when you find out that there's a probationer who has made admissions like these?
Can you state that again?
What's your usual process when you find out a probationer has made admissions?
Usually what happens is if they're in another county, the county will contact me by phone and tell me what happened, and then they will either email or send me hard copies in the mail. And then once I get those, I file the motion to revoke and send it over to the court.
Do you have any reason to not believe the admissions when they're given to you?
Objection, Your Honor, proper opinion.
Sustained.
Did you base your motion to revoke based off of those opinions
Objection, Your Honor.
or those admissions?
Your Honor, that calls for an answer based off of hearsay.
Sustained.
Would you file a motion to revoke if you believe that the allegations were not true?
Objection, Your Honor, improper opinion and calls for an answer to be based off of hearsay.
Overruled. I don't think it was specific. I don't think his question was specific to this motion. I think it was in general.
Yes, Judge.
Good answer.
Question again?
Would you file a motion to revoke if you believe the allegations were not true?
No.
Were those documents made a part of the probation file for this case?
Yes.
Your Honor, may we approach?
All right, Mr. Rodriguez, the state has made an oral motion to withdraw its motion to adjudicate in your case. That means that you're going to be, if there's no other holds on you by any other law enforcement agencies, then you're going to be released today. You are going to be continued on supervision. Mr. Manning may discuss issues with you concerning the refiling of this motion and a future hearing. So doesn't mean that the issues are resolved, but it means as for today, they have requested that the motion be withdrawn and the court has granted them. All right, so whenever you are released, check back in with your probation officer that you're still on the same probation that you ordered on April 28th, 2022. Ask Mr. Manning, ask Mr. Manning any questions you have.
You know, I may just have to shoot, before you think about it, I'll think to that.
Okay, all right, if there's nothing further, then we're adjourned. This no, it was admitted. It was admitted, so we can go ahead. That one. Or actually, let's see, hang on, no, let me have those. They were offered. Did you offer these?
Only one. Only states one.
Do you need these at all?
I just need states one. That was admitted. Do you have states one? There's nothing here.
That's one. All right, that concludes the court's docket for the day. Yes, that concludes the court's docket for the day. The court is adjourned.